It's a fairly endemic problem, isn't it, in the profession of specialists not really having enough empathy with non-specialists to be able to communicate as clearly as they might?
Well, in most judges, with rare exception, most judges are generalists. And as I said, you may be the world's leading expert in a particular question of patent law, and, more power to you, I'm not. And so if you can't translate that expertise down to my level, you're not going to reach me, and it's not going to help you at the end of the day.
One of my good friends is a writing professor named John Trimble, English professor. He came up with a formulation that readers are impatient to get the goods, and they're going to resent having to work any harder than necessary to get them. Do you think that's true of judges?
I do. In the sense that that's a more elegant way of putting it than my kind of machete hacking through the overgrowth, but it's the same point. I as a judge, have a responsibility to try to get the right answer on the law. This brief is going to help me one way or another, and I want to get that help out of it. And if you can't express clearly what your position is, that's not helping me. And if I have to work hard just to understand the facts in a case, again, that's going to impede my efforts, not help them along.
In practice, did you do much contractual drafting?
No, I didn't. I did some, but that I was usually involved in litigation of one form or another.
But you probably still have a useful opinion on how contractual drafting could be improved. Let me pose
I guess it gets back a point I made earlier. One thing that I think is devastating to effective drafting is the word processor. I've seen so many lawyers that when the next deal they get, they go back and get copies of the contracts for the last deal, and they press a button and it prints out, and then they try to modify it. I'm not saying, it's not my area of the law, so I don't really know it that well, but I'm not saying you should reinvent the wheel every time. But it's good to think about what it is you're trying to accomplish and use the normal words that will get you to that objective. That'll improve drafting rather than simply building layer upon layer of past transactions.
How could legislative drafting be improved?
I think one way would be to stop using it as a veil for disagreement. The reason you have bad language sometimes is because they're trying to find a way for people who have two different objectives to agree on the same language. And that's not a good thing. That just transfers the problem from the legislature to the court. If you really have agreed on a law and what it should accomplish, again, try to use as clear and simple and direct language as possible to achieve that result.
Do you think contracts and statutes can both be worded in good idiomatic English?
I do, and I think people tend to get a little obsessed with structure to the detriment of language. You see that in statutes. Well, we're in clause A, 5, 3, II, and so they've got to do it all still building off of this. Well, at some point you can end the sentence and you can start another one. Courts will be able to figure that out just as much as, something going down there. And of course, the process is a handicap. It's a little bit. You don't get somebody sitting there saying, well, I'm going to write this law. I'm going to add, subdivision X314 to the law, and so it just squeezes it in there, and it doesn't, that could be an impediment to good writing, and I think complex contract negotiation may be the same as well. You don't have the freedom of, you don't have a pride of authorship in the whole structure, so no one's really invested in that, and it can lead to great confusion.
Do you think that it would be wise for more law firms to hire professional editors and proofreaders?
Well, I worry a little bit about a disconnect between the substance and the writing. You can't. I think it's hard to have somebody come in and say, I'm good at writing. Let me see what you've got, and I'll change it, because writing is a reflection of the underlying substance. You can't have somebody come in and just sort of gloss over it and make it better, because then you're going to give it back to somebody who's going to say, well, I might read better. That's not what I meant, or that's not. You don't quite have the right point there. So that disconnect between the writing and the thought, I think, is a problem.
As a practitioner, did you ever encounter court rules that made it hard to write a compelling brief?
I'm trying to think. I always had problems with some court rule or another. Sometimes they impose a structure that doesn't really make a lot of sense in a particular case. You know, you begin with the statement of the case, then a statement of the facts, and you couldn't really quite tell what it was, and it didn't always make sense to me to follow the format.
Would you ever just add an introduction before that stuff to make it
almost
clear?
Always, to be honest with you. If it was all, I sometimes have to check and make sure it was all right with them. As far as the rules go, there's no petty tyrant with such power than the person in the clerk's office who's going to bounce your brief because it begins with an introduction rather than the required statement of authorities of the case or whatever. But yes.
You never actually had one bounced, did you?
Oh, sure. And
for putting an introduction?
For stylistic liberties of that sort,
mm-hmm.
yes, from time to time. Well, they let you refile it after you call it something else or whatever. But yes, I particularly in a brief, I think an introduction, which is different than a summary. It's almost never sort of, in part one I'm going to say this, and in part two I'm going to say this, and in part three I'm going to say this. It's more, this is a story about what happened when this, and this, and, the court below said this, and the reason that's wrong is because of this and this. And then, go into it. But to give them an idea of not a roadmap, not a summary, but your main argument. Again, it's sort of the written equivalent of, those first couple of sentences at oral argument.
What's your advice? This is the toughest question that I get from junior lawyers. What's your advice for a forlorn junior lawyer who's trying to hone writing skills but works for a senior lawyer who's mired in jargon?
The first thing to realize is that lawyers are professionals, and something that comes from being a professional that I've always found about our profession is that your value is not judged on how senior or junior you are. You're both equal. You're both lawyers, and so don't worry about that. Even a lawyer who's mired in jargon, I found if you put good writing in front of them, they'll understand that and see it, and I think that's just the thing to do. Because from my experience, judges aren't mired in jargon. We don't really like it when we get a brief filled with jargon when clear writing would have done a better job.
When you approach an oral argument as a judge, to what extent do you have a tentative vote in mind? Is there a kind of rebuttable presumption?
It really varies on the case. Some cases seem clear. You look at the briefs and you're just not persuaded by one side and you are by another. So you do go in with I'm kind of leaning this way. Usually you've got concerns. I'm leaning this way, but I wonder what I need a better answer to this problem. Or I'm leaning this way, but I'm worried about this case. Does it really seem to cut the other way? I'm leaning this way, but is it really going to cause this issue? So even when you're tentatively leaning, you have issues that you want to raise that give the other side a chance to sway you. Some cases you go in and you don't have a clue, and you're really looking forward to the argument because you want a little greater degree of certainty than, hard to tell. Other cases you go in and you seem, they're competing certainties. The language sure seems pretty clear this way. It really leads to some bad results. What are you going to do? Or, yes, this precedent does seem to control, but I think, this consequence is too troubling. Or the Congress seemed to have a different idea in mind here. And then you've got to work that out. That's a much more typical situation going into argument.
What is your own tendency as a judge when you have clear language? It's very clear to you that it couldn't have been what Congress contemplated, and an unjust result, but the language is clear.
You know, our precedents make it clear we're supposed to go with the language in almost every case, because again, those are the building blocks of our profession and the law. It also, you know, issues of institutional competence enter into it. The language binds me. An assessment of how significant the consequences are is a little more subjective, and you assume that the people who wrote the language were familiar with that as well. So you can't give a categorical answer, but when you get those conflicts, I think it's the time when you do need to pause and consider the institutional issues. What does it mean for you as a judge to say, the language is clear, but I'm not going to follow it because I don't like where it leads?
Some years ago, Justice Stevens wrote a crisp 5-paragraph majority opinion that occupied less than one printed page. What would happen if the court started doing more of those?
We could all leave earlier in the spring, I guess, than the summer, which is not true. I'm sure that it's harder to write shorter and crisper than it is to write long and dull. I think that would be good. I'm not one that thinks there's a great value in long expositions. Chief Justice Rehnquist certainly was known for his briefer and crisper opinions. Can't always do it. Sometimes you need a little more room to explain things. Sometimes, and you have to remember, this is a collegial enterprise, and when you're judging authorship, you have to appreciate that compromises are made to get a court. Somebody says, put in this language to get a vote. It may not be the language I would have chosen, but I'll do it if I need the vote. So it'd be good in some cases. We still do that, and Justice Stevens still does it, and I hope more people do. If we can do things succinctly, the more succinctly, the better.
What would happen if a justice were to tell a law clerk, we finished the opinion, it's one of these average length opinions, which seem to have gotten longer over the last 50 years, although I guess they've gotten shorter over the last 20, haven't they?
I've seen different studies on it, yeah.
And then to say, good job, now let's cut it in half. Let's summarize this and keep the reasoning in.
Well, I've told the story about one of the drafts I did for Justice Rehnquist, but I did my job on it, and he came in and circled a lot of things and said, let's put all these things in footnote. It was sort of like everything other than the topic sentence of each paragraph. He said, we can put this all in footnotes. And I said, all right. So I went back and gave him a draft with all that stuff in footnotes, and he looked at it and said, fine. He said, now cut out all the footnotes, which was his way of communicating that you could do it in a leaner way, which has very clear benefits. I mean, when we look at old precedents or even precedents from more recent times, a lot of the excess verbiage leads to difficulty and confusion, and the leaner you can keep an opinion, the better it is as a guide to the future.
When you were a circuit judge, did you have the opinion that Supreme Court opinions are overwritten?
Yes. When I was a lawyer, I had that. I mean, if you look at it and you're trying to tell a client if they can do something, you got a lot more to deal with on a particular issue that often seems to add confusion rather than clarity. I try to guard against that in writing opinions, but you're not always successful.